Here's the latest in Second Amendment news. This one might upset you a little bit. On Monday, the Supreme Court denied cert in challenges to two very important gun rights cases: Maryland's assault weapons ban and Rhode Island's magazine capacity restrictions in cases known as Snope and Ocean State. For those unfamiliar, denying cert means that the Supreme Court is not going to hear those cases. And of course, with these cases, it was a long road to denial as they've been relisted over 10 times. The justices provided no insight into why Ocean State was denied, other than noting that Justices Thomas, Alito, and Gorsuch would have elected to hear the case, and unfortunately, that's one short of the four needed to grant a petition. Snope was given a bit more explanation for the denial with two separate comments. Justice Kavanaugh provided a statement respecting the denial of cert, stating, "Given that millions of Americans own AR-15s and that a significant majority of the states allow possession of those rifles, petitioners have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment under Heller." He further added, "In short, under this court's precedents, the Fourth Circuit's decision is questionable." Although the court today denies certiorari, a denial of certiorari does not mean that the court agrees with the lower court decision or that the issue is not worthy of review. The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeals. Hinting towards the future, Kavanaugh concludes, "Opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for certiorari will likely be before this court shortly, and in my view, this court should and presumably will address the AR-15 issue soon in the next term or two." And for those wondering, the Supreme Court's term for when they hear cases and release opinions runs from October to June or July of the following year. So basically we're looking at next year or the year after, starting in October. Thomas was more direct in his dissent, stating, "The Fourth Circuit held that AR-15s are not arms protected by the Second Amendment. I would grant certiorari to review this surprising conclusion." Thomas points out that the Fourth Circuit erred twice over in reaching its conclusion that a ban on AR-15s passes constitutional muster. First, they place the burden on the petitioners to demonstrate the Second Amendment protects their right to keep and bear AR-15s, not the government to prove that they may be regulated. This, of course, turns the Supreme Court's test spelled out in Bruin on its head. Second, Thomas takes issue with the Fourth Circuit's finding that AR-15s fall within the historic exception for dangerous and unusual weapons. Remember, that's a conjunctive test, meaning that the firearm has to be both, not one or the other. Thomas continues, "I want you all to hear this. I cannot see how AR-15s fall outside the Second Amendment's protection." Yeah, me neither. He also noted that the court has avoided this issue for a full decade, and that further percolation is of little value when the lower courts in the jurisdictions that ban AR-15s appear bent on distorting this court's Second Amendment precedents. And one of the most important things he said, at least to me, was this: "Until we are vigilant in enforcing it, the right to bear arms will remain a second-class right." The court punting on this issue again only emboldens state legislatures to ban one of the most commonly owned types of firearms in the United States and leaves millions of Americans stuck in limbo, unable to fully exercise their Second Amendment rights by choosing a firearm most suitable for their purposes. The Second Amendment Foundation, my actual employer, has 7 other assault weapons ban cases pending, and there's some others out there as well. While this denial of cert was disappointing, if there's any good news that's coming of this, it's at least this: there's some other bites at the apple in the future. So, I want to know, how many of you live in a state where there's some kind of restriction on your Second Amendment rights? And how many of you live in a state that has an assault weapons ban? Are birds government drones sent to spy on you? Are polar bears real? Have you ever seen one up close? Let me know down in the comments. Welcome back to the Big 2A, the show where we bring you all the top Second Amendment stories. I'm your host, Adam Kraut, and no, birds are not real. There's even a website for that. We're trying to make sure that more people see this show, so hit that like button below. If we get to 6,000 likes on this show, John will buy me a pizza. It's only a personal pan pizza, but whatever, please help. Seriously, I'm starving hardest here. Now, for some positive 2A news. ATF has announced a new policy to replace the Biden-era zero-tolerance policy that decimated the number of FFLs. And in case you missed it, 195 licenses were revoked in 2024, up from 2023's record-setting total of 173. That was more than 2% of all licenses inspected, which was its highest revocation rate since 2005. And that's way bad. The new policy requires serious willful violations before administrative action, such as revocation, can occur. Minor or clerical errors will instead be addressed with warnings or education efforts. Now, having managed an FFL and also handled FFL revocation hearings during my time in private practice, I can tell you this is a good thing. You see, under the Gun Control Act, or GCA, all that's needed to revoke a license is a single willful violation. Something as simple as an error on the 4473, such as transposing a number, or country being written in the box for county is enough, at least under the statute or regulations, to revoke a license. And willful doesn't have the definition you would think. Under the new policy, mirroring the old interpretation, the term means having a purposeful disregard of, plain indifference to, or a reckless disregard of a known legal obligation. So, you can see where this would get ugly real quick. Oh, and that known legal obligation, it's covered during your opening conference with ATF, where they go through all of the laws and regulations with a sheet saying they discussed it with the licensee, and the licensee initials a box on each line for the topic covered, but in reality, it's more like you can find that information here. Here being a book that used to be published, or the law and regulations themselves. We all lawyers now! So, new policy's approach to education and warnings to bring dealers into compliance is certainly a better approach than just shutting them down. Additionally, automatic license revocation is out, and inspectors will need to consider intent, compliance history, and public safety risks for each case from now on. The new policy is more directly focused on whether the licensee continuing to sell firearms would pose a public safety threat or contribute to violent crime. Back when I was still working as a real lawyer and dealing with FFLs who had compliance issues, we'd just create a remedial plan to show how they'd fix the issues moving forward. Those are things ATF will now seemingly consider again when looking at whether to revoke a license or not. I know we all love to hate on the ATF, but as long as the GCA exists, someone is going to have to do the regulatory thing. And a more friendly, work with the industry to ensure compliance type ATF is a better pathway to ensure access to arms by Americans continues to exist. Speaking of abolishing the ATF, the Trump administration has floated a plan to do just that. Yay! Or is it really yay? The DEA's proposed 2026 budget has revealed that the White House is pushing forward on the idea of merging the ATF with the DEA. That's right, the government wants to merge the ATF into the DEA in order to better combat foreign terrorist organization drug cartels. According to the budget proposal, ATF will be incorporated into DEA, addressing both drug and gun crimes. Now, I don't think you need to be an expert on government to understand why this is a terrible idea. To begin, DEA's budget is almost 2.5 times the size of ATF's, and it has twice the number of employees. And oh yeah, you remember all those ATF raids that resulted in people dying? Well, DEA has 4 times the number of tactical teams that ATF does. And let's not forget that DEA doesn't exactly have a sterling reputation when it comes to respecting the rights of people either. As Reuters is reporting, this move could happen as early as October of this year. However, it does require congressional approval, so it's not a guarantee it will come to fruition. I can only imagine the atrocities that would come from this new version of the agencies. Pretty funny, right? We'll be keeping an eye on this one as it moves forward. Next up this week, Washington's Governor Sideshow Bob, signed a new law implementing purchase permits to obtain a firearm in the Evergreen state. The push for purchase permits is a tactic we're seeing used nationally in an attempt to stifle an individual's ability to acquire the necessary tools to exercise their Second Amendment rights. The new law will require those interested in purchasing guns to apply for a 5-year permit through the Washington State Patrol. Applicants must pay a fee and have completed a certified firearms safety training program within the past 5 years, with a few limited exceptions. Ah, there it is. Have to pay to play. And let's be honest, the background check performed to issue the permit is no different than the background check performed at the time of purchase. So if a person's prohibited, they're not getting the gun either way, whether there's a permit system in place or not. The new law also requires a live fire portion in order to even obtain a permit to purchase. So I guess if you don't own a gun, It's coming on you to figure that one out. Good luck. The Washington State Standard is reporting that the State Patrol expects the new program will cost just over $20 million in the 2027 to 2029 budget cycle, and that fees collected for fingerprinting and background checks would help offset that cost. In fact, it'll offset it so much that they could bring in $15 million over the 20 they're expected to spend, according to the latest fiscal analysis. Anyone else see a problem with this? What are they for? For profit or something? The good news, if any, the new law doesn't go into effect until 2027, so there's going to be plenty of time to lay out a robust litigation strategy before its implementation. More ATF news, they've added 2 more states to the list for use of CCW permits in lieu of a NICS check when purchasing a gun. Last week, the agency announced that Michigan and Alabama now qualify, bringing the total number of states with this exemption to 28. That means there's 28 different states that you don't need a NICS check if you have a valid CCW. Current law allows for a permit to be used as an alternative to the NICS background check, provided the permit complies with 3 requirements. 1, the permit must allow the non-licensee to possess or acquire a firearm. 2, the permit must have been issued not more than 5 years earlier by the state in which the transfer is to take place. And 3, state law must provide that the permit was to be issued only after an authorized government official verified that the information available to them does not indicate that it would be a violation of the law for the permit holder to possess a firearm. Of course, if an FFL doesn't want to accept the permit, they don't have to, particularly if they believe it's invalid, improperly issued, or otherwise does not meet the requirements of state or federal law, in which case they're calling NICS. However, the addition of 2 more states is trending in the right direction for gun owners to be able to purchase guns without being subjected to the delays and outages of NICS or their state police if they're in a point of contact state. And that's good news for gun rights.